welcome everyone. Well, I will take advantage of this dead air to read the extremely exciting recording disclaimer. This webinar is being recorded for educational and training purposes. This recording may include questions and poll responses provided to you during the live event. This recording will be made available after the conclusion of the live event and posted on the Carlton Fields website. So welcome everyone. My name is Michael Yeager. I am joined here with my fantastic colleagues, Patricia Trish Carrero and Tino Lucella. We're coming to you from New York and Miami. So we're here to talk to you about cyber fraud. Fraud is always changing, and regulators pass new rules, and that creates change, or they just take new approaches under old rules. And we're going to glide through and survey some areas with a few deeper dives and takeaways. There was a Q&A feature in the chat. Feel free to put in a question at any time. I noticed one person asked if it was recorded, and then we answered. And we will answer the questions at the end, probably, not throughout, unless somehow the spirit takes us. And finally, let me first just introduce myself before I pass this over to my colleagues to introduce themselves. I am Michael Yeager. I am a partner here in Carlton's New York office. I practice in the cybersecurity and government investigations groups. And I got into cybersecurity through the Fourth Amendment. I was a federal prosecutor, an assistant U.S. attorney in the Eastern District of New York, and I was a computer hacking and intellectual property coordinator and prosecuting cybercrime and helping the office out with new technologies. I got involved in this area, and here I am. Trish, if you could tell us about yourself.
Sure. Hi, everyone. My name is Trish Carrero. I am in the Miami office, primarily in the privacy and cybersecurity group. I am certified by the International Association of Privacy Professionals, so as both a certified information privacy professional and as a certified information privacy manager. I am co-chair of their South Florida chapter, and one of my primary focus areas is privacy and cybersecurity in the financial services industry. I'll pass it to Tino.
Yes, thank you.
And good afternoon. My name is Tino Lucella. I'm part of Carlton Fields' security litigation and enforcement practice, and my practice also spans white collar crimes and investigations and tax controversy. Happy to be with you.
All right, well, take us away, Tino.
Right. So I'm going to start off by talking a little bit about the SEC and FINRA's work in the space of cyber security issues, mainly through the discussion of Regulation S-ID and a little bit of Regulation S-P. I got involved in this area because prior to joining the firm, I was a director in enforcement at FINRA and was part of the enforcement team that brought the first Regulation S-ID case in 2020. So first, what is Reg S-ID and to whom does it apply? So Reg S-ID is a red flags rule that the SEC enacted in 2013. And the goal of the rule is to identify, prevent, and mitigate loss from identity theft and intrusions into financial institutions' systems, and that's what I'll be talking a lot about in my portion of this webinar. So even though it was enacted in 2013, there was a long lead-in of implementation, and so the SEC actually didn't bring its first action in this space until 2016, actually 2018. And based on an intrusion that occurred in 2016. So in that case, there was a financial institution where hackers posed as representatives of the financial institution and called in to the firm's IT department, posing as representatives of the firm. and were able to get password resets and ultimately get into the system, penetrate the firm's system, and obtain access to thousands of people's personally identifiable information. And there's a lot of lessons that can be learned from an intrusion like that. But starting a little bit with the end result and how it got there is, I think, part of the helpful discussion, which is the SEC ultimately brought action against this financial institution for both Regulation S-ID and Regulation S-P violations. Regulation S-ID and S-P are very closely related and oftentimes can be charged together. So while Regulation S-ID intends to regulate and detect, identify, prevent, mitigate account intrusions, Reg S-P is designed to safeguard customers' information. So you may say, isn't that looking at the same thing? But oftentimes, especially through actions that you'll see FINRA, for instance, take in the Regulation S-P space, that could involve a representative who intends to leave one firm and join another firm and take customer information with them in a way that was inconsistent with the privacy notices sent to customers of the first firm. And so it's not all about intrusion into a computer system to steal PII. It could simply be the mishandling of PII. And so in certain instances, you could have Reg S-P violation without a Reg S-ID violation. I think the flip side of that, when there is a Reg S-ID violation, and in the first action FINRA brought, it only charged Reg S-ID. I think there's oftentimes more of an overlap where Reg S-P could also be charged, and that's something that I'm sure regulators are thinking about. And these involve significant penalties when a regulator perceives that you've run a financial institution's run afoul of the rules. So the 2018 action that the SEC brought resulted in $1 million fine against that financial institution. And thankfully in that case, even though there was an intrusion, there was no known transfers of funds, et cetera. So this was based on an intrusion, and what the SEC then alleged were unreasonable procedures, and then the procedures that the financial institution had, they didn't implement correctly. And so some of the things in that case that stood out, at least to me, was the firm maintained and had procedures about lists that it would maintain when there were suspicious phone calls, where there were phishing, where there were suspicious IP addresses engaged in potentially nefarious activity. And the firm, though, didn't have a mechanism for really in a real-time way cross-referencing this information. And so when the intrusion in 2016 occurred that served as the basis of this formal action brought against the financial institution, some of the numbers from which the intruders called were on the firm's watch list. And so I think that was a real concern of the SEC's. And in fact, when the firm first learned of an intrusion, they froze some, but not all, of the IP addresses. And it's easy to sit here today and Monday morning quarterback and sort of dissect what happened and think to yourself, well, isn't it obvious that they should have froze all the IP addresses? But when you're dealing with this in real time, it presents a challenge. Because you don't want to be, I could imagine as a financial institution, you don't want to be over-inclusive in freezing IP addresses, because what if you capture legitimate ones in there? And so this is not by any means a criticism of what that firm did, but what stood out to me as something that financial institutions should be thinking through along the way. And so similarly, in the first FINRA action, in that matter, in 2018, the dual-hatted CEO and CCO of the firm began getting those bounce back emails, the ones that everyone colloquially refers to as the mailer demons, where it says this couldn't be delivered to the intended party, etc. And for months, this CEO and CCO ignored those messages. And eventually, after several months, called the email vendor to ask what was going on. And it had turned out that there was an intrusion into their system months before, and that someone put a rule on the email address belonging to the CEO and CCO such that any emails going in or out would be automatically forwarded to this intruder's email address. Now, that intrusion lasted a while. It resulted in approximately 17,000 emails being blind copied to this third-party email address. And it resulted in a fine of $65,000 from FINRA and certain undertakings that the firm was required to accomplish. Now, there were issues that caused FINRA concern, not the least of which was that all of these emails are coming in saying bounced back with the email address that was unknown to the firm, to the CEO, and to the CCO, and he didn't immediately try to tie that down. What's going on? He didn't call the email vendor on day one, or even week one, or even month one. So that was an issue. But then looking at the firm's procedures, the firm had procedures that contemplated, if there was an intrusion, contacting the firm's internal legal department. The problem was the firm didn't have an internal legal department. And that's something that I know Trish and Michael and I will speak about.
Sounds unfortunate.
Right. That's something that we'll talk about on the back end. I don't want you to think that all of our viewers think we're just sort of throwing up these problems and not helping you address them. At the end, we're going to have a little bit of a dialogue about what you could do to mitigate risk in the face of these real-time issues. But here, needless to say, procedures should mirror the business that you're in. And so that's what had happened there. It didn't mirror the business they were in. And that leads you to believe they just sort of downloading off-the-shelf procedures without narrowly tailoring them to your business. And to that point, in actually this summer, the SEC released 3 more actions in the Reg S-ID space. So even though the rule was enacted in 2013 and they didn't do anything until 18, now it seems to be heating up. It was included in the 2022 SEC examination priority letters that they would be looking at this. And it looks like they're following through, because in July, the SEC issued 3 more actions alleging Reg S-ID violations against certain financial institutions. And I think what's important to note there is the first action the SEC brought and the first action FINRA brought were based on actual intrusions into the systems. And through those actual intrusions, the SEC and FINRA had different criticisms for the policies and procedures that led to them, but they weren't the starting point of the violations. If you look at the actions the SEC took this summer, those were based on policies and procedures and systems alone. In the orders that were disclosed, there wasn't a mention of a breach. And going to the point of making sure the policies and procedures financial institutions have make sense for the type of business they do, one of those 3 actions, the SEC criticized the financial institution for describing a red flag that it couldn't possibly follow through on. And in that matter, what happened was it said it's a red flag if the photograph or physical description of a client was inconsistent with the client's appearance. The problem, nearly all of the financial institution's accounts were opened online. And they, the financial institution would never be able to compare the physical appearance with the identification presented. And so that's a real red flag, not to use the word in different ways. The firm says it's a red flag, but it's a red flag to the SEC because they say, well, if are you just copying and pasting these from various sources instead of really thinking through your business and developing red flags that are red flags specific to the institution you're in?
So Tina, if I could jump in there,
Sure.
it sounds like, first of all, we've moved from there was an intrusion to your systems just stink, right? So now it can just be your systems stink. And number two, yes, tailoring to your industry, but also just literally, what do you do? Say what you're going to do what you're going to say. Don't say something if you don't talk about a legal department if you don't have one. Don't diagnose a problem in such a way that you couldn't possibly address it, because then you won't address it. I mean, I will say very quickly, I have seen this in designing written information security plans for different investment advisors. And they'll get consultants sometimes who will give them 60-page plans. And this is a hedge fund with about 900 million AUM. They're not going to follow a 60-page plan. They're going to follow a 20-page plan. So it isn't always the case that more is better. Oh, let's list more risks and somehow we'll be better. It has to tie to the real world.
You're exactly right. And I think that one thing that stuck out to me in these recent releases that the SEC announced in July was the amount of the fines. So they range from $425,000 to $1.2 million. So on the high end, it was higher than when there was an actual breach in 2018, the 2016 breach that resulted in the 2018 action. So I think that reinforces what everyone, particularly in the securities industry, knows, which is the SEC is becoming more aggressive in terms of levying higher fines. I know a lot of our participants listening in are associated with insurance, the insurance industry. I think that many of the same concerns are applicable. You have accounts of customers. Those in providing insurance products, you necessarily have PII of those customers. And so the same concerns, I think, are applicable. And when we talk about mitigation later, I think that the mitigation we talk about with respect to the financial institutions regulated by the SEC and FINRA are also going to be applicable to the financial institution or to the insurance agencies as well.
Well, picking up on that, Trish, I know you were going to talk about various things. Maybe one of them was account takeovers litigation, but if you could just lead us into your topics.
Sure, yeah. And to pick up on Tino's point about, look, if there are changes and it's not directly applicable to you, you still probably shouldn't ignore them because it shows a larger direction, right? The different regulators that you are subject to, these regulators, yes, they're regulating different entities, but the same concepts come up across these regulations. So, coming on board now, most of the provisions for the FTC's 2021 Safeguards Rule amendments are coming into force very soon. And that was essentially expanding upon the requirements, one that insurers and banks were already doing, but expanding it to the non-bank financial institutions, right? But again, what it was putting forward is, hey, you need comprehensive security systems. You need to have vendor oversight. And we're going to be explicit about some of these requirements that we're not going to excuse you from not having. So we want to see encryption. We want to see MFA being used. We want to see secure disposal of your documents. You better be monitoring your systems, keeping activity logs, having a written incident response plan, testing and monitoring the effectiveness of your controls. We want to see the penetration testing being done, vulnerability assessments. We want to see a qualified individual actually appointed and looking over these things. We want written risk assessments, annual reports to the board of directors, ongoing training. These are all sort of common things that are becoming more and more required and having more and more rulemaking around them. So just sort of being more explicit is what I'm getting a sense of from the regulators. So you also had CFPB putting out its circular earlier this year that just said, look, to remove any question here, if you have insufficient protections of sensitive consumer information, that is an unfair act, right? And then for insurance companies, it goes even deeper to turn this more to the focus on fraud. You have the NAIC's Insurance Fraud Prevention Model Act. A few states have passed it, but most states have some sort of insurance fraud statute. If we're looking at the NAIC model, then there's mandatory reporting of incidents of fraud, and there's this requirement to have anti-fraud initiatives in place to detect the fraud, prosecute it, and prevent it. And I think it's just a sign of more to come, right? There's a lot of rulemaking going on. The SEC is proposing more cybersecurity rules. You have within the SEC's strategic plan for 2022 to 2026, goal number 1, protecting working families from fraud. And then you have DOL, so the Department of Labor is looking at rulemaking, specifically account takeovers appears to be a very big focus for them. I think all this comes from a threat that's been identified by everyone, right? I mean, we look at the numbers and we see cybercrime increasing 300% since the start of COVID because so many things have gone online and digital. You see insurance fraud ballooning to over $300 billion a year. Leading among that, life insurers who have faced $75 billion per year in losses from fraud. And account takeovers play a very big piece of that. So to speak to just account takeovers, focus on that for a bit, since it is such a focus, especially I'll say with DOL at the moment, and when you have these retirement accounts, because retirement accounts, unlike your normal, say, checking account, you may not look so closely at, right? You may not monitor every statement. Sometimes if the market's doing particularly bad, you may want to spare yourself looking at that retirement account and how it's doing at the moment. But there are steps to an account takeover fraud. I view it as sort of 5 steps, right? First, that gathering of the personal information you're going to use to take over that account. Then you get access to the account, you assume that role, you cover your tracks. So usually that's where you're going to be changing the contact information, right? The address becomes your address. The email address may become your email address, or you've compromised this person's email address and you set up, as Tino was talking about, a rule where the messages are going to be deleted. And so the person, when they go to check their email, won't see that new email from the financial institution or from their insurer saying, yes, we've got your new contact information on file. And then finally emptying the account and disappearing, of course. And these account takeovers can be very simple. It can be very complicated. So when you're looking at the sort of typical fraud, the simple kind, fraudster gets in, uses the personal information to get in the account, resets the password, changes the contact information, empties the account, and gone. Very simple, straightforward. But there are also the more advanced versions of it that are more complex and that really make you think, wow, if these fraudsters had decided to, choose better careers, they really could have contributed well to society because this is clever. So recently you may have seen that there were hackers who took over at least 31 retail brokerage accounts, right? They're not just compromising one, they're compromising all these retail brokerage accounts, and they use them to purchase stock. Now the fraudsters already controlled large blocks of stock in these companies, so they're then able to sell their holdings at artificially high prices, right?
Classic pump and dump.
Yes, and a tremendous amount of effort to accomplish this. But when we're talking about these things and we're thinking about, okay, so what can we do? I view it as falling into sort of 3 things: protect, detect, respond. And these are the things that I think regulators look for. So, and Tino and Mike, by all means, hop in here. I'll just sort of run through the first few that come to mind in each of those for me. But beginning with protect, yes, it's your usual cybersecurity protections, right? And making sure that your policies and procedures are in place and actually, tailored to your company and working for you. So that's the security program requirements, right? Making sure you're complying, you have the qualified individual MFA, encryption, password protection, you're patching things, you're updating things, you're testing your systems, you're training your people, all important. Vendor management, right? You're doing due diligence on the people that you are giving information to. So if you are hiring a company to monitor and run and administer the employee retirement account, for example, making sure that they're actually going to be looking out for these red flags, looking out for fraud.
I want to jump in there for a second.
Yeah.
I will say the majority of, I mean, a bare majority, but the majority of intrusions I've worked on since 2014 have been vendor-based intrusions. I mean, that's just the place a lot of this comes. So that means when you onboard these people, there's diligence, and not just in contractual protections, but actual diligence. And continuing, don't set and forget. I mean, that is the place that you see things, employee phishing too, but first and foremost, oh, it happened to our vendor. Often too, you have smaller vendors.
Yeah, or you have vendors that have shown up a lot in these fraud actions, right? When the same vendor keeps showing up in enforcement actions, and then you hear of someone that's about to use that vendor, it sort of makes you pause and be like, let's consider this and make sure that we are looking a little deeper. And as you mentioned, like the contract terms play a huge role in that, right? I mean, allotting risk to your vendor, having insurance to actually support that risk if that vendor goes under, and having audits that are happening and actually getting those done and seeing, okay, what is being returned on this vendor and can I continue to trust them with this information? Also risk assessments in your security program, you know, the typical things that you would expect. Board involvement, I feel like, is becoming more and more stressed. So making sure you actually have those reports to your board. And with everything, leave a good paper trail, right? If you are taking these steps and going through all these actions, make sure you're writing that down so that when a regulator comes knocking and says, hey, I noticed you didn't do X, Y, Z, you can say, yeah, but I did, you know, A through V.
And
give me some credit there.
Yeah, and you know, going to your comment about the board, you know, Regulation S-ID on the front end requires involvement of the board, or if delegated, to an appropriate committee of the board. So the regulation contemplates board involvement, and I agree. You know, there's better practices on how to write your record what you've considered and how often you've considered it. But the fact that it's in writing somewhere is important, because one of the ideas behind Regulation S-ID is that as cyber fraud evolves, so too will the financial institutions program.
Yeah.
So in one of those other actions that the SEC brought this summer, a criticism was that the financial institution hadn't updated its policies and procedures regarding cyber intrusion since 2008. And what does the internet and what does cybersecurity look like now compared to 2008? I mean, it's different world. And so that periodic update, recording the fact that you've talked, that the institutions involved the board of directors, that they've considered things. And I think also not only learning from the financial institution's own breach, but looking at the news. And if another similarly situated financial institution had a breach at that institution, thinking internally, well, if that happened there, what can we learn about it? And are we susceptible to the intrusion in the same way?
I mean, so jumping on that piece, look, prosecutors and regulators read the newspaper too. And sometimes that's where they get their ideas. So that does come up. I mean, I would say, look, you can still basically reduce all of the law of cybersecurity into the statement, take reasonable security measures. And the basic problem there is that the word reasonable changes over time. That is to say, the substance of what is reasonable changes over time, as Tina was saying. As the tech changes, what's reasonable changes. At this point, you desperately need multi-factor authentication, to the point that regulators aren't just saying large principles of, they're also requiring individual protective measures. I have my own concerns about such a specific prescription of particular tech. I'm not sure that's the greatest thing for regulators to be doing generally. But when an item starts falling onto that list of mandated individual steps, that is certainly a cue to, oh, it's unreasonable not to have it. I mean, the last thing I'll say on that is, another way to think of it is, would it be embarrassing if this happened? If the Chinese military, the People's Liberation Army, get access to your personal computer, that's not really embarrassing, because how the heck were you going to prevent that? On the other hand, if you had a password that was 12345, it's pretty embarrassing. So it's kind of a gut check for what you have to do, and what's embarrassing changes over time.
Yeah, one thing I'll mention too is if you are going to use some new technologies for fraud detection, be aware that you need to make sure that you have the right privacy policies and notices, or have gotten the consent that you need to have it in place, or that in itself becomes a liability. So this that you've put in place to try to detect fraud can create all sorts of privacy issues for you if, say, you haven't provided or haven't received a written consent that you're required to do under a particular law. Moving to that, and then to detection too, making sure, yes, the cyber side that we've spoken about, but also fraud prevention specifically. And for this, account takeovers, again, is a great example, looking for those red flags. And I'd say those red flags especially relate to changes, right? You have a change of address, and then it's coming quickly by a loan request or a surrender request, and it's going to a new address. That needs a second look. Or this person has been a customer for a long time. Now they're signing up for online registration, and quickly comes a loan request or a surrender. They're requesting a wire or a payment that's going to a brand new bank account. There should be a pause, right? Or they have an emergency request, right? This urgency that also pairs with account changes. Don't be fooled into being like, it's an emergency, I have to move quickly. It's like, no, policies and procedures are in place. We've trained our employees and they follow those policies and procedures. Or anytime someone's trying to hide their identity, right? If the address is changed and now it's a PO box or transient lodging, or they're using a mail.com address, so, anonymous email services, ordinary people don't generally use that, right? Why are you so concerned with our not being able to reach back out to you or know who you are? If you're getting calls over like VoIP, right? Voice over internet protocols, it usually takes a pause. You see a falsified, doctor documents, of course, that should raise flags. Or you see just discrepancies across communication methods. I spoke to the person over the phone, they had perfect grammar, but they can't seem to be able to put together a sentence in this, written request that I got from them. They're seeming like two different people. Maybe they are, right? And so you have to look into that, and ensuring that any change that happens, so the password changes, the contact information changes, those go to new and old contacts, and you have waiting periods in place between, say, a beneficiary change and getting distributions out of that. The one other point I'll mention on detection, because we have been seeing enforcement action surrounding it, is considering doing an audit of your SAR filings, right? And making sure that those are including all the information that they're supposed to, because we have seen actions where essentially the regulator looked back and said, if you'd actually filed the SAR filings the way you were supposed to have and included all the information there, we would have caught this sooner. And of course, that did not lead good places for that entity. So then turning to responding to these things, right? Planning ahead to mitigate your losses. One, data minimization, right? To the extent you can. Document retention and deletion policies, I think, are just more and more important. And then one thing that we had discussed earlier was this idea of like knowing about frauds that are going on. You may want to consider fraud share, right? It's an information clearinghouse and alert system, was set up by like 10 major financial services firms. And it allows the entities to like collaborate and share data, especially on account takeover activity. So that can be very worthwhile. Again, written incident response plan, very important. There's been studies, it actually saves money in responding to these incidents. Complying with your reporting obligations when they happen, right? Because this, if you have an incident, is not the sort of thing that you should not be reporting and waiting for the regulator to find, right? Because it's part of a normal examination that you're going to be subject to. It's not really something that you can just, we'll pretend it didn't happen, because when it gets uncovered during normal examination, it really doesn't go well. And the last thing I will mention on this is, and we've seen some success here, that one of our clients, actually, there was an account takeover situation and they fought back. And usually you don't hear about this, and it's not usually what most clients do. But what happened was they said, well, we can't go after the people in the call center, they're overseas. But hey, the person who owns them, they were able to find and was within the US, and they went after that person. And they said they noticed a marked decrease in the amount of fraud attempts they were facing. So apparently word got out. And as with many things with fraud, you don't want to be the low-hanging fruit.
You know, Trish, a bunch of what you've said in terms of best practices, it occurred to me that where sometimes institutions sort of fall short, at least in regulators' views, are they don't train their people. And so if you're going to go through the expense and the effort of making sure that your institution is in compliance with the various Regulation S-ID, other privacy laws and provisions, and have a robust cybersecurity program, it's only good if you train your people on it, and so they know what to do. So as Trish said, you know, if there's red flags that come up during a conversation with a customer, the person on the other end of that phone call who works for the institution has to be empowered with the knowledge of what do I do. And so oftentimes when I was part of a regulator, I would see statements in policies and procedures that would say elevate. If you see a red flag, elevate it. Well, but the policies and procedures never defined what a red flag was and to whom the person should elevate it. And so, you know, having some prescriptive red flags, and you could say including but not limited to, but give some of the common examples, update those examples, and then say, if you see any of those examples, report it to whomever. And sometimes you see they'll put in a person's name. That wouldn't be my first recommendation. I would say the position, because turnover, regulators come in and say, okay, who's Jane Smith? And then the institution says, oh, she was the chief information officer in 2018. We've had 8 since then. And so keeping it positionally based, I think, is important.
Absolutely. So, I mean, now seems like a decent time to go in our other direction, which is the New York DFS, regulator here in my home state, which has something of an outsized influence. They've been trying to grab cybersecurity turf for years, and they've had some success with a pretty influential set of rules that we usually just call Part 500 for where they are in the New York Code of Regulations. And they took effect back in March of 2017. And now there's some new proposed regs. I mean, the DFS rules have had some influence. One of the things that, if you know one thing about the Part 500, it's the 72-hour notification rule for certain kinds of cybersecurity events. And there's this kind of machismo where the regulators are all vying to have the soonest regulation. I mean, I noticed the SEC's recent proposal that investment funds and advisors have to report significant cybersecurity incidents within 48 hours. So they're going to be the person that you're most worried about. That has not taken effect yet. It's just a proposal, and who knows, with the SEC, depending on what the election happens, maybe it won't. But in July of this year, DFS imposed some big changes to its rules. I'm going to summarize them and then talk about their implications. They are, of course, undergoing comment, and they could change. And quite frankly, I would encourage people on this call to consider whether their institution should comment. I've been involved with comments in the DFS in the past, and they have made changes. I mean, they're really sophisticated institutions have pointed things out that they didn't know, and they moderated some of their issues. One in particular, there was going to be a rule requiring end-to-end encryption at every single second. And there was a credit card processor who pointed out that the way that they had designed their encryption requirement in these original rules would prevent the processor from doing some of its fraud checks. And so they needed to have a few milliseconds where they didn't have to encrypt. The reg was changed. So first of all, oh, and I guess I should say also as an overarching comment on these new changes, basically the bottom line, they're giving reasons that you're going to probably have to increase your tech spend and your compliance spend. So the first piece of the new proposed regulations are obligations for big companies that they define as Class A companies. Companies with over 2,000 employees or over 1 billion in annual revenue averaged over 3 years. And the changes they're proposing include annual cyber audits, scanning of your system weekly, password vaulting, banning common passwords, endpoint detection to monitor anonymous activity across the system, including lateral movement, centralized logging across systems. These are things that a lot of people are already doing, although perhaps not as many annual audits. In some ways, this is setting down in stone things that were probably already advisable and many institutions are doing, but this stuff is uneven. And DFS does have a pretty wide group of people that it regulates, all things considered, between banking, insurance, mortgage lenders. The biggest thing I think is the audits. And one thing I think the implications there is that there are going to be more statements by employees about security and the way things are done. I mean, Tino commented earlier about how there was a mismatch between what people were said they were doing and what they were doing. Well, anytime the regulator forces you to write something down and you're talking to the auditor, you're doing this, you are creating the potential for that issue. And there's just got to be some agreement, some fit between your words and your actions. At the cybersecurity symposium in March that DFS held, there were some employees speaking, and they also reported about stuff they'd been doing as part of their Part 500 exams. And one of the things they mentioned was a use that they were thinking of using in 2023, the cybersecurity infotech baseline risk questions, a questionnaire. Well, that's another document. If there's a civil lawsuit and there's a civil litigant, this is the kind of thing that's going to be on the document requests and that people are going to use as grist for that mill for those private actions. So that's new obligations for big companies. Other piece of the proposed regs, governance changes. They want independence for the CISO, for the Chief Information Security Officer. Also hooking into things that I believe Trish and Tina have said, they want more board reporting. Right now, the requirement is for annual reporting. They're going to add reports on material issues and events and remediating inadequacies. There's a big purchase in the middle of the year. There's a change of systems. I mean, material is another lawyer's word. So there's some flexibility there, but it's the kind of word that also has a lot of case law behind it. What else in governance? Well, they're going to want some board experts to exercise effective oversight of cyber risk. And the board has to approve cybersecurity policies. That's a bit of a change. Look, you know, in the early 2000s, serving on audit committees became a much bigger thing in boards. Cyber is kind of following that trend. And depending on the nature of your business, you may need to have an increase in expertise at the board level. Last thing in this category, right now, the annual certification, one of the scarier parts of things that the DFS requires, can be done by a senior officer. The proposed change is that it has to be done by the CEO and the CISO. So that's significant too. That's a way to have individual people to target. I mean, you know, when I'm wearing my white collar hat and we're doing government investigations, there's a bit of pronouncements by the DOJ recently on individual responsibility of corporate officers. A lot of it isn't new, some of it is. And these kinds of certifications also can become the kind of thing that gets looked at by other regulators. I mean, that's sort of the consequence here, is you're getting this piecemeal stuff that can be collected from different regulators in different ways. You do want to have some kind of awareness of what the whole thing amounts to and what's out there. This is inherently interdisciplinary. You know, often the lawyers are the coordinators. Obviously, we are not technologists. I mean, we're like lawyers who can read a balance statement, when you know, a balance sheet, right? Lawyers who are good with accounting, they're not accountants. Likewise, we're comfortable with technologists, but we are not technologists. And I expect the same is true inside most large institutions. This is interdisciplinary. So what's happened also that seems to tie into these kinds of things, these new certifications, these new audits, in the past, there have been a few cases brought against companies for poor security. So what Tina was talking about earlier with the shift from just there was an intrusion to your security stinks. Well, that's happened at the DFS. And the cases that jump out were people who didn't have multi-factor authentication. And because they didn't have multi-factor authentication, and that's, you know, when you're logging into your system, you have to have not just a password, but a randomized number on an app, or if you're really cool, on a physical security dongle, a YubiKey or something. That's what they do at Google. No multi-factor authentication was the issue. And since their security was bad, their certification was false. When they said they had good security, that was used against them. Another thing, risk assessments. They said tailor it to your specific organization. For the reasons Tina went into, you should be doing that anyway. That's actually a terrible thing, to have a risk assessment that is not tailored to what you do and who you are. You don't want that. Technology. Now there's going to be a requirement, or when this takes effect, I presume in 2023, for asset inventories. Now you should be doing asset inventories anyway. What data do you have and where does it sit? But now there's a little bit more specificity for what they're requiring. And so you may have to build that into your asset inventory. So they say, oh, you've got inventory, your information systems and components. That includes hardware, operation systems, applications, infrastructure devices, APIs, cloud services. Look, in a company which has a bring your own device policy, this is not a small task. With the consumerization of tech for large companies where individual employees are often purchasing the item, data sits in a lot of different places. And the asset inventory is a classic example of the problems with set and forget. By definition, you're going to have to keep updating it. This is a valuable thing to do, but now things are moving from best practices to required. Frankly, that may be the heaviest lift in the near future to deal with this reg as it's coming, is you may want to look into your asset inventory so that you can be ready for this reg. Trying to move quickly. No, we're running out of some time here. Notifications. They're talking about a 72-hour notification for access to privileged accounts or deployment of ransomware within a material part of company information systems. Was this covered before? Probably. It's a cybersecurity event. But now, instead of us just saying, well, was that material or not, they're taking out a particular example of an event and throwing it up to something you have to respond to. They've set it out in the reg, this proposed reg. Also a 24-hour notification for any extortion payment, so within a day, and 30 days for explaining why you're paying, alternatives considered, your sanctions diligence, looking at the OFAC list and the SDN list to make sure they're not banned by Treasury, people you can't pay. People who've had to go through that know that that's kind of like a separate CLE. Okay. Where I want to end with this. What's going on in this last stuff you're seeing is a huge amount of interest in ransomware and extortion payments. And I think this is a nice little test case of how this crosses the boundaries between regulators and areas. because first of all, they're clearly talking about OFAC. Second of all, there's been some major news recently about extortion payments and criminal prosecutions of CISOs. I'm referring to the Uber case, right? Where the former security officer at Uber was charged and convicted for obstruction of justice and misprision of a felony because he concealed an attack that had happened while the FTC was investigating an earlier attack. The FTC was investigating a 2014 breach, and he was covering up a 2016 breach, theft of Uber drivers and customers' personal information. And basically, he said that the extortion payment was a bug bounty award and covered it up this way. There are definitely special facts about this. For one thing, the chief security officer is a former federal prosecutor, a very experienced person who also took it upon himself not to get the general counsel involved and to just freelance on this thing. So there are definitely extra pieces of it. But what's going on here is the DFS regs have the potential for making this Uber case applicable to a wider range of people because of those audits, because of those certifications, because of those notification payments. They're setting this up that you could get closer to this, okay? And, you know, you have to think about this when you're designing these programs. A bug bounty is a great thing, a program where if people find security flaws, they get paid for it. You're crowdsourcing security, you're setting up a market, paying people to look for flaws. I love this stuff. You got to be clear about how you design it, though. What bugs are eligible? What would the payment be? You know, if you've got a bug bounty out there that says 5,000 and then you're paying somebody who says they're a researcher and they found a flaw and they're going to release the data unless you pay them for the flaw and the payment is $200,000, that's materially higher than your $5,000 bug bounty, and that'll probably be a bit suspicious. These sorts of things come into play. So you can see how they kind of interact with each other. And my bottom line on the DFS stuff is one of the biggest implications is what it could do for other regulators and for private litigants when they have these sources out there. So Trish.
Yeah, actually, Mike, we have a question in the chat that is directed. It's about New York DFS. So if you want to chime in on that one, you've answered part of it, but the other part of it is basically your thoughts as to whether, you know, too prescriptive, does it not go far enough? Opinions?
My instinct on this stuff is perhaps a little too prescriptive. To be fair, that's the kind of thing that may never materialize because it's like when it gets old is when these are a problem. Oh, everybody should have a firewall, of course, except 10 years from now when we've done something completely different that makes firewalls irrelevant somehow, right? Right now, I don't think they're going to be too prescriptive. They're tracking practice, but you reify things, you lock them in. A regulator has to update their own things, just as you need to do an annual audit, regulators need to update. And I have far more confidence in the people on this call updating than I do with regulators updating, quite frankly. You know, Tino, there's these proposed new SEC changes. A good thing, a bad thing? Do you think they're going to happen?
You know, I think it's hard to predict what will happen, but I think that sort of overarchingly, regardless of what happens, sort of falling back on the basic principles that we've talked about so much today, really, I think is essential. Being proactive, documenting what you're doing and how often you're doing it. And I mean, in the ever-changing space of cybersecurity, once a year is a minimum, right? I mean, things change faster than once a year. I was thinking, Michael, when you were talking about multi-factor authentication, and how that's a must, and thinking about the SEC, at least in one of those cases, criticizing an institution for not updating its procedure until since 2008. Fun fact, I just looked it up. The first iPhone was released June 29, 2007. So it wasn't much after that. That was the last time one of those institutions updated their cybersecurity procedures. And the first iPhone came in 4 gigabyte, 8 gigabyte, and 16 gigabyte sizes. Think about the capacity of what you're able to do with your phone now versus halfway through 2007. And so I think that that just underscores the importance of periodically thinking through with your board of directors or a committee of the board of directors, what's changed since we last met? And do we need to look at our procedures and modify? And I often think to myself, if you modify as you go, it's a lot easier than sort of writing them and forgetting about them for 5 years and then having to play catch up.
Absolutely.
Yeah, and it's to your point earlier that you made about the importance of training too, I think comes into that, because new things occur, new trends begin. And if you're not informing your employees about them, then that's going to come back to you, right?
Absolutely. Well, I think we here are at 12:59. If anyone has final thoughts, I think I've said my piece, but thanks very much for
joining.
coming.
Thank you
Yeah.
for joining.
All right, guys. See you soon.
Bye.